So thank you very much once again, and I hope and wish that you all, are safe and stay safe as you carry on with your profession, which of course is at the front line of what all of us are facing today. We want to cover two parts about medico-legal cases and liability today. One is about what is the kind of trend and the kind of cases that the medical fraternity is seeing today, right, from patients, and what kind of cases are these? And second, what is the impact of the Consumer Protection Act, considering these cases, right? Right at the start, President FOGSI did, highlight how when healthcare as an industry, is clubbed with other consumer services, it is bound for litigation to rise, right? So we'll cover both these aspects today in our presentation. First thing for us to understand is what is the need for professional indemnity insurance? What is it that is really bothering doctors all around? Is the rise of litigation against doctors. So by various studies, you would find that lawsuits in India against doctors is on a multifold increase. We are slowly and gradually catching up to the West in multiple dimensions, but also as a litigant society. There is a high level of consumerism that is getting into the Indian fabric. With that, a very high level of activism, right? And the need for patients to assert themselves, because of which cases against doctors is also on the rise. If you look at some of the broad nature of these cases, you will find that more than 1/4 of the cases are simply because the patient's expectation did not get met. It is not necessarily about the doctor giving a negligent service. If patients are unhappy with the outcome, they tend to go and file a case against the doctor, right? Whether or not the doctor is at fault is for the court to decide. But what does happen is a case is filed against the doctor and the doctor has to start defending themselves. I think what we have to first understand, a number of esteemed guests did speak about do no harm, which is the principle that doctors live by. But what we are talking about here is customer expectation on the rise, because of which litigations are increasing. About 1/5 of the cases are filed today because patients are anxious about their health and they have limited knowledge. In a lot of these cases, patients are supplementing their knowledge by researching on the web. By simple internet searches, they think they have the facts, because of which they can counter a doctor. And thereafter, if there is a mismatch, they feel free to go and file a case in the court. The irony of all of this is that a large amount of these defense expenses that go to pay the lawyer fee is borne by the doctors themselves. So studies indicate that about 85% of the legal costs are actually paid by the doctor, which need not be the case if you have the right kind of professional indemnity insurance, which we'll cover in a bit. Now, we are organizing this session from the point of view of West UP. So it is also important for us to understand what is the share of cases by states across the country for medical negligence. And it is not such a great news that UP ranks today as amongst the #1 state, along with Madhya Pradesh, in terms of medical negligence case at a state level, right? So when you look at the top states, UP and Madhya Pradesh together contribute to 13.25% of all medical legal cases at state consumer level. The other aspect that we have to think about is what is the proportion of cases for our concerned field here, for this, which the chapter belongs to, which is the gynecology broader field, more than 1/4 of all cases today belongs to the gynecology department, right? This, of course, is based upon a sample of data of 4 states, but one can construe this could be representative of larger country as well. So as a member of this particular profession, you have to be conscious that gynecology does attract a lot of medico-legal cases. Now, this slide talks about the outcome of such cases. As I told you, that many of these cases are filed because the patients are dissatisfied, and it is for the court to decide whether or not the doctor is at fault, right? And what this slide would show you is that in around 1/3 of the case, about 30% of the cases, the doctor was found negligent. Now, we will also talk about the kind of negligence that courts have ruled against the doctors, and what does our current legislation say. But as per the survey, about in 30% of the cases, doctors have been found negligent. But in the remaining around 70% of the cases where doctor has not been found negligent, you must note that a large amount of legal expenses have been borne by the doctor, right? Apart from the agony that they would have faced for facing litigation, they also have to bear the legal cost. I want to talk to you about what is the kind of outcome that medical negligence cases are seeing in the country. I'm not sure how many of you are aware, but a landmark judgment in medical negligence was established through the case of Anuradha Saha. Just to give you a brief of this case, Anuradha Saha was a patient who ultimately died. Her case was she had developed some skin rashes for which she had gone to see a doctor. The doctor advised her some steroids which had an adverse effect on her, ultimately because of which she succumbed to death. This case was then filed by her husband, right, in various courts where he alleged medical negligence, and the negligence was finally upheld by the Supreme Court, where the case against the doctor was about prescribing wrong medication. You must know that this case went on for 15 years. At various forums, the case was first decided in favor of the doctors, but because the patient's kin kept on pursuing the case right up to the Supreme Court level, the case was finally decided in favor of the plaintiff. So for 15 years, the doctors and the hospital had to defend themselves, right? And the first positive side for the plaintiff, the Supreme Court expanded the definition of medical negligence, because of which the National Forum awarded compensation to the victim. Thereafter, the victim was, the plaintiff was still not satisfied, because of which they went back to the Supreme Court for increasing the award, which the Supreme Court did. And they awarded a compensation of 5.96 crores, right, against the doctor as well as the hospital. This was AMRI Hospital in Calcutta. And when you club the interest cost that the Supreme Court asked the hospital and doctors to pay, in total it amounted to more than 11 crore rupees. So this is the highest compensation awarded by Supreme Court of India on a medical negligence case, right? The other case, closer to home, about what kind of cases today come for perinatology, which is very close to what you do, right? And this is a recent case of 2019, right, which relates to Master Rishabh Sharma. Now, the first case we saw was about wrong medical advice in terms of the medication prescribed. In this case, the moot question was that certain diagnostics which ought to be prescribed was actually not prescribed by the doctor. To give you a synopsis of the case, there was a preterm baby that was born at 32 weeks. And as per routine procedure, preterm babies are susceptible to retinopathy or illness. It was not prescribed by the doctor. After some time, the baby was diagnosed with ROP of stage 5, and and the baby ultimately turned blind. Now, the mother alleged medical negligence. It went for different forums. The case was decided against the doctor, wherein it was held after putting in the Bolma test that ROP should have been prescribed. It should have been followed through as the patient came for multiple consultation, but because it was not done, the doctor was held negligent and liable to pay compensation. Further in the case, it was shown that there was some fabrication of documents as well, where the doctor in the defense said that ROP was done, but when it was further investigated, it looked suspicious, and the court held that the procedure was not done as it should have been done as per the expert panel, and that's why the compensation was awarded, both to the baby as well as to the mother. Now, the big difference here is this is about just not prescribing a test which could have avoided such a situation, like a case of blindness for the baby. And the compensation was in the tune of 76 lakhs. This case was against Maharaja Agression Hospital. Now, what you have to take away is that given this kind of situations, right, both in terms of litigation as well as the compensation, the role of a professional indemnity insurance is for you to cover the compensation as well as the litigation cost. A professional indemnity insurance would cover any kind of compensation which is awarded by the court for disability, injury, or even death of the patient, and it covers the incidental acts and working done by your unqualified staff and technicians as well. What I would like to also highlight here is that it is known to us that a lot of doctors tend to buy a professional indemnity insurance as well as buy a subscription for legal fees, right, which is not required. A standard professional indemnity insurance offered by SecureNow covers the cost of lawyers, right, wherein you don't have to pay a separate subscription for legal fees to defend yourself. So in case a legal notice comes to you, the professional indemnity insurance itself will pay for the lawyer cost, and you don't have to buy a separate legal subscription. And the cost of it is very reasonable, as Abhishek will tell you in a bit. Now, we come to the second aspect, right? So far, any questions? I just thought I will just lay the context first for medical negligence and the kind of cases. Okay, I'll just continue. I was just checking on the streaming side as well if there was any question. The second aspect is about what is the implication of the Consumer Protection Act 2019 for the healthcare industry, right? One of the cases which has been, again, a landmark case is the case of Indian Medical Association versus VP Shantha, right? This was a case where it was decided by Supreme Court, and this was a case of 1995. It was decided by Supreme Court that if doctors are giving a service in lieu of fees, they are liable under the Consumer Protection Act. Now, and this was Consumer Protection Act of 1986. Now, when the Consumer Protection Act of 2019 was brought to force, there was a big debate about whether healthcare should be part of it or not. Initially, healthcare was part of it, but then later, because of objections from various forums of doctors, healthcare was dropped out of the CPA Act of 2019. The reason given by the minister on the floor of the House was that we want to pass the bill and we want to avoid controversy, because of which we are dropping healthcare as a term. Now, what is important to note here is that while healthcare was dropped as a from the definition of consumer, consumer products or consumer services, it was not excluded from CPA 2019. And there's a big distinction in that. Just because it was dropped, healthcare is not automatically considered as a non-consumer service. There has been a lot of arguments for and against about this. Very recently, this is as recent as 2021, where a doctors forum went to the Bombay High Court and filed a PIL saying that doctors should be kept outside of the CPA, and all the cases filed under district forums should be repealed, and consumers should not be allowed to file cases against doctors in district forums. But the Bombay High Court, in fact, took a very strict stand and said that just because the new act is being formed where healthcare is not included as a service, it does not change status quo, right? In fact, what they did was they put a penalty on the petitioner, saying it is a frivolous litigation, and they imposed a cost of 50,000 rupees. So with this judgment and with this context and the kind of precedents that we have already discussed, it is well established that doctors are still liable under Consumer Protection Act, right? And all the different provisions of the act also applies to doctors, right? So as far as legal dispute is concerned about whether healthcare is considered part of CPA or not is now put to rest in many ways. Now, what is important for you to understand why CPA 2019 has got so much attention, and why is it now become a big concern for doctors, right? And that is where, when you look at the differences between CPA 1986 and CPA 2019, it'll bring many things to light. Number one, if you would lose a case, right, at a district forum and go to a state forum for appeal, right, the mandatory deposits earlier in the earlier act was capped at 25,000 rupees. Now that has been increased to 50% of the total awarded compensation. So in the two cases that we just spoke about, if the district forum were to file a case or give a compensation of 50 lakh rupees, then you cannot just deposit 25,000 rupees and get away. You have to deposit 25 lakh rupees before you can appeal to the higher court, right? So that is a big distinction, right, between what the earlier act said and now what we have prevailing. The second aspect, which is also very important, is what was the pecuniary jurisdiction of various forums. So earlier, the district court was, had a jurisdiction of only up to 20 lakh rupees, right? Whereas now it has become up to 1 crore rupee, right? So the district forum can decide for cases up to 1 crore rupee. The other big distinction here is that earlier, district forum had a jurisdiction of 20 lakh rupees for compensation awarded. Now, the district forum has a jurisdiction of 1 crore rupee for the value of services tendered. Now, if you can think about it, in almost all cases, doctors will never, offer a service which will go above 1 crore rupee, right? So it has become very straightforward for all consumers to file a case only first in the district forum. They don't have to go to the state or the national forum as their first port of call. And as you may already be aware, that to file a case in district forum is fairly easy, right? So, and in case the decision is not in favor of the plaintiff, they can go and appeal to multiple forums, state and national forums, right? So that elongates the litigation journey for a doctor as far as the CPA is concerned. One of the good points of CPA is about the mediation cell. So earlier, CPA 1986 did not have a provision for mediation cell. Now the court has the power to refer cases for mediation between the two parties, right? And that is a very critical thing, because it enables you to settle the matter outside litigation, right? And we have also included some of these provisions in our professional indemnity insurance where out-of-court settlement is covered, which makes life easier for you if things come to that. The last point, which is also very important for doctors to understand and appreciate, is that earlier the CPA said that the case has to be filed where the seller or the defendant was located, so where the doctor is practicing. Now it is moved much more towards the consumer or the patient, so they can file a claim where they usually reside. So in case you have outstation patients who come and see you at your practice, if once they go back home, they can file claim in their respective district forum rather than what is convenient for you, right? So what that necessitates is that you should have access to a network of lawyers, right, who can defend you in different parts of the country. Otherwise, it can become a harassment for you if you are based out of Kanpur and your a complaint has been filed for you in Calcutta. Just imagine the horror, just because you have to commute or you don't have a network there. How will you defend yourself in a district forum in different parts of the country? Now, within the CPA Act, there are a few things that a doctor should be very, very careful about. CPA Act also now defines unfair trade practices, right? Now, I have highlighted a few points that could be a issue when you think about the medical practice in general, right? Amongst other things, two things that the CPA Act stipulates is that if you don't issue proper cash memo or bill for the service that you render, it can be classified as an unfair trade practice, right? There may be a lot of situations where doctors don't necessarily give a bill or receipt, right, for prescription. Now, that could be classified as an unfair practice as far as the CPA Act 2019 is concerned, right? So doctors have to be careful about this given the change in regulations, number one. Number two is about disclosing personal information, right? Now, the way we work as a society, sometimes this could be, we may not have very strict boundaries, but what the Consumer Act now stipulates is that the information of the consumer should not be passed on to a third party without their permission. There have been cases where when the information of the wife is passed on to the husband, right? Counsel has taken a negative view of that. There was a case where the wife was being treated by the doctor, and the information, the medical information of the wife was passed on by the doctor to the husband, because of which there was a divorce between husband and wife. And the wife then, filed a complaint against the doctor that it was my personal information and you had no right to share this with my husband without my consent. And if I recall it correctly, it was the Telangana Medical Council which did hold a negative view against the doctor, right? So the breach of confidential information is again an important aspect that you have to think about within the scope of your professional indemnity insurance. It has become now very easy for people to file claim within CPA. You can do an e-complaint. As I said, the location of the complainant is important, not that of the service provider. The court fees have been reduced, and the consumer courts itself have the power to review their cases. I would finally like to conclude with a court's observation especially of the Karnataka High Court, who itself says that it has now been observed that a section of the society are prone to filing, cases against doctors and hospitals. When this observation comes from the High Court itself, it's a warning signal for people to know that, certainly litigation against doctors is on the rise. Dr. Aruna, what you said is a very pertinent point. Now, when you think about lawyers, there is a big, spectrum of lawyers today, right? There is a lawyer who is doing murder defense also, and there's a lawyer who is doing defense of doctors as well. Now, what is important is that whenever you have a litigation or you have a legal notice, you should be defended by someone who is an expert in medico-legal cases, right? Because if you are an expert in medico-legal cases, they would have understood your situation. Because, for example, the way Dr. Aruna is practicing and the way Dr. Archana is practicing would not be very vastly different. Some of the issues will be structural. For example, the way Dr. Archana ma'am said that we are, like companies, we are not, having a company secretary, right, to do all our compliances. That is the company's job. As doctors, it is mostly an individual practice, a hospital where you don't have so much legal bandwidth to spare. Now, this is an issue common across all doctors, right? So if you have an advocate, if you have a lawyer who understands medico-legal cases, right?
How will we know about that?
So, ma'am, that is the reason why we want to collaborate with you.
We have done for ISOPARB. What we are doing, we are actually covering all these. I think Abhishek sir has actually discussed few points here. We are covering the litigation, pre-litigation cost. So pre-litigation cost is when you get a legal notice. Most of the time, many insurance companies don't cover that, or in your standard policy, it is not covered. But we have negotiated, and the pre-litigation cost is also covered. As you mentioned, ma'am, as soon as you get a notice, you need to inform us, and we will appoint a lawyer for you within 24 hours. So that's the part of SecureNow. You need not to go to the insurance company directly. We are there to mediate and do everything for you. So you can just simply send the legal notice. We will inform the insurance company. The lawyer will be appointed, and you need to narrate and then send the documents, relevant documents, to the lawyer, and then the lawyer will draft a reply on your behalf. Again, the compensation is directly paid by the insurer. So it's not that you need to pay and then you need to claim from the insurance company. That is part of the standard R policy. We cover criminal cases arising out of the medical accidents. So till the time it is not proven, those cases are also covered. Breach of confidentiality, which is a kind of data protection act, which Abhishek sir discussed, that the information about wife was informed to the husband. So those are also covered. Defamation cases are also covered. AOY is very important point, ma'am, which is if you have taken a policy of 1 CR and you get one case of 1 CR, it is covered. So any one accident, any 1 year, which means that in many cases it is 1:5. So even if you have taken a policy of 1 CR, the insurer will pay you only 20 lakhs if it is 1:5. If it is 1:2, he will pay only 50 lakhs. Here, what we have done, we have negotiated for the entire premium amount that you have taken. We have negotiated the premium, and the premium is very, very low. The ME policy also covers the unqualified staff and nurses, visiting doctors, and there is no member required. Something which Abhishek sir also mentioned, we don't charge for legal fees. So whatever premium you are paying to the insurance company. Even if you get a legal notice or there is a case, there is no legal membership fee. Most of the organizations, they charge for 3 years, which is like 24,000 rupees or so. But then here we don't charge even a single penny extra. So these are the benefits that we would be offering to the members. How this system works, let me just tell you that as well. So I think the point which Abhishek sir shared in the Consumer Protection Act of 2019. So we have gone ahead and negotiated that with the insurer. The mandatory deposit, we have done that part with the insurer. So if there is if you want to go to higher court and then you want to appeal, the amount will be paid by the insurer. again, the district forum has gone up to a limit of 1 CR. So as mentioned, we have negotiated the premiums, and now very many existing doctors who have taken a policy of like, let's say 30 lakhs or 50 lakhs are now going for 1 CR cover. Surgeons are actually going for a cover of 2 CR and 5 CR as well. Mediation centers, because of the number of cases in different courts, they generally refer it to the mediation center, which is kind of out of court settlement. So that is also covered under our negotiated policy. Jurisdiction, again, indemnity insurance covers practice of doctors throughout the India. So it is not that if you are part of UP, it is covered only the UP. No, it is covered throughout the India. So that is also there in this extended cover for CPA 2019 by SecureNow. How our system works, I just show you that as well. Okay, so as soon as you receive a legal notice, as ma'am said, Archana ma'am, you need to call our SecureNow desk. We have a dedicated number. You need to inform through email and through phone. We will register a claim with the insurer, and within 24 hours, we will appoint a lawyer for your case. You need to give the entire case history to the lawyer. Lawyer will defend the case on your behalf. And in case if any compensation is awarded, it will be paid by the insurance company. So that's a very simple process, ma'am. We have the escalation matrix, as many a times you would not get the proper information. So we have the escalation matrix. You can come up to me or to Abhishek sir as well, for that matter, if you don't get a proper response from, just in case. So this is how we cover. And as Abhishek sir mentioned, we have around 180, 190 cases. And those cases are well taken care of as of now. The process of making the policy on the website is very, very simple. You can go on SecureNow website, and you can click on the professional indemnity. It's here, ma'am. So you go on the profession, and under that, you just need to put your details, your specialization. So if you are, just click on your specialization, and it will give you the codes. It will give you ICICI Lombard, it will give you Future Generali and United India. You can change the sum insured from the left side. If you want to go to 1 CR, that's the cover. And you can see that with 6,000 with ICICI Lombard or Future Generali, you can simply buy the policy. With ICICI Lombard, you will get the instant intimation, and within few days, you get the policy through United. Few of the policies are instant. So there is no manual intervention required. You just simply go on the website and can buy the policy online as well. So that's a feature. We have integrated our site with different association as well. Like IRIA, we have integrated. So if any member of IRIA can go on their own website, the association website, and can opt for the personal accident or the professional indemnity. So if you click on, so this is IRA website, and they need to simply click on professional indemnity, and it will take them to the same page. So this is how we work, and this is the logo that we can do for your association as well.